Welcome to In Critical Times, a Native American perspective. Today, we're talking about one of the most pressing issues in really over 4 decades, as we are in the verge of what could become a just unbelievably challenging time once again for our Indigenous communities and our Indigenous children, as the Indian Child Welfare Act is set to go before the Supreme Court. And this is not a challenge just on our children's safety, which we've been fighting for and against since the very first touch of colonization on our lands, but also a challenge against tribal sovereignty. And so we're thankful today to have an amazing panel for you, and a panel that's very skilled. And I want to get and start by just introducing them and let them tell you just a little bit about themselves. Decora, if you don't mind, just lead in and let our listeners know who you are and just a little bit about yourself.
Ambeti Washte Yuhape, everyone. My name is Decora Hawk. I am the field organizer for Lakota People's Law Project. I'm based here in Thunder Valley, South Dakota. I am really excited to be here on this panel and to talk about the importance of ICWA and how it pertains to our Indigenous communities. So thank you for letting me sit on this panel. Hechegla Wopila.
Absolutely. We're also really honored to have Dov, who's doing a tremendous and important work, and we're going to talk about that later on. Dov, do you mind just introducing yourself to our viewers?
Hey everybody, my name is Dov Korff-Korn. I'm the clerk for the Lakota People's Law Project. I am based kind of everywhere. At the moment, I'm in Anchorage, Alaska, but I spend a lot of my time in the East Coast and in the Southwest, and often in Lakota country too. I'm a law student. I'll be starting my third year at NYU Law in New York City. But I'm going to study for a certificate in Native Hawaiian law at the University of Hawaii starting in late August. So I'm on the road, but I work closely with Lakota Law and on this brief as well for Brad Keene.
Absolutely. And once again, I appreciate so much this panel coming with us. Decora, and we're going to talk about this a little bit in just a moment. She's helping fight in different areas as well as with Child Protective Services and a program that's going on right now. Obviously, Dov has been absolutely crucial in our quest to try to uphold our way of life and our way of protecting our children and our sovereignty. At this moment, we're going to play a video for you. And I believe this video will be very crucial to kind of lead into this discussion overall. But we had in this discussion, they'll give you just kind of a background of ICWA and the importance of that. So we're going to go to that video now from 2013. And of course, it's even more pressing now, but I do think it lays a very good foundation for us as we go forward in these discussions.
What I want to do this morning is to walk you through the history of how we got to ICWA, and then talk a little bit about the fact that ICWA really is best practice. 1958, the Indian Adoption Project was created. And this was a joint effort of the Bureau of Indian Affairs and the Child Welfare League of America. In the 1950s, CWLA was the cutting edge thinking, the most progressive ideas about how to properly raise children. And the project had as its goal the placement of Indian children taken from homes that were, quote, deemed unsuitable. What happened was that the states were actually paid by the Bureau of Indian Affairs to remove Indian children under the rubric of neglect. Transracial placements were encouraged because the goal was to get those kids away from their families and away from their communities, put them in a white home where they then had a chance at a modern life. In this time period, 25 to 35% of all Indian children in the country were removed from their families. Western science has finally gotten around to the place the tribal people have known for a long time. Relationships, family, are what are essential for healthy children to grow. What's happened, though, is Western science is up here, tribal traditions are over here, So we have people who think they're helping kids, removing them into institutions or stranger care because it's already licensed. And what we're actually doing is we're hurting kids in the name of helping.
Hurting instead of helping. I think that can kind of lay out the foundation of this nation's policy toward our nations for many, many years and many, many situations. And there have been people that came with good intentions, but good intentions never resulted in necessarily good actions. And I want to go to our panelists in just a moment. Before we do, I would like to lay just a little bit more of a foundation so that we can begin to get their insight from this. But I think it's important to understand, as we talk about many times, our ancestors were in this land before colonization reached this land. And once colonization reached this land, they then began to, you know the stories. There were different ways that people ended up on reservations. Some were the Trail of Tears or the Long Walk. Many different tribes had different ways that they ended up on reservations. I always like to say, and with our Lakota tribes, it was after the Red Clouds Wars and after the 2-year wars that we defeated the United States in the war. We made the decision, and many things were with that, the Black Hills and all, but many of our people began to move on reservations. And the United States policy for reservations was very clear. Their intentions was for us to die out as a people on these reservations. But what happens so many times when we're counted out and they don't think we can do it, we flourished and we even grew in population. So then they begin to try to cut back rations, and they begin to cut back on their promises, and they're failing on their treaties and what they promised that they would do. And when that didn't work, they then begin to move to their next level, and that was assimilation. And they begin to create these schools. I always think it's important to note who the first headmaster of one of these Indian boarding schools were. Kill the Indian, save the man boarding schools. And it was a man by the name of General Pratt, who was not an educator. He was not a philosopher. He was not a person that had great experience in education and higher education. He was the leader of a prisoner of war camp of the Apaches. And during his time there, he began to realize, or he thought, that he could assimilate these Apaches to become good people. And he helped launch what was called the Carlisle Industrial School, the very first of many hundreds of these boarding schools. But he made this statement which showed clearly what the intention was. He said, "You've heard it said that there is no good Indian. The only good Indian is a dead Indian." And he said, "I agree with that in this, that if you can kill the Indian within them, then you can make them good people and good citizens." And so it started close on reservations. They moved off moved them off the reservation because we were still too strong in our culture. And they begin to separate our people from their community, the way we've always known life, the way we've always wanted life. And they moved them into these residential schools. And as they moved them into these residential schools, the first thing that happened is they begin to cut their hair. This thing that we take so much pride in, they cut it off. They took their traditional garments and gave them military style clothes. They went from the military style clothes to then changing many of their names to more white sounding, colonized sounding names. And they were beaten if they spoke their language. Not encouraged to speak another language or to learn a second language, but beaten. Many times sexually assaulted anytime they would do anything within their language and within their culture. And this was our life for decades and decades. And then we had the land swoops of the 60s and the 70s. And I always like to point to 1972, and it's only about 5 miles from where we're at now. The American Indian movement moved into the Wounded Knee area and said enough is enough. With people like Russell Means, Dennis Banks, Madonna Thunderhawk, these people took a stand and said, enough is enough. We are going to be who we are as Indigenous people. And ultimately, after 70 days of gunfire and many other things and just making this stand, that pride of being who we are once again begin to rise up. And in 1978, they passed the Indian Child Welfare Act as they did this study and found that as we are separated from our people and our culture and our life ways and our languages, we begin to not become better people, but we begin to diminish in our success and what we should be, because it's not who we were created to be. And so with that said, they passed, and I think it's important also to know they passed the Indian Religion Freedom Act. A lot of people don't realize that until 1978, we could be arrested and put in jail for simply celebrating and going to our version of church, whatever that might be, wherever you are. So in 1978, these two laws passed. And they have been the foundation of us trying to win back our culture and our life way and who we are. And from that, now I do think it's important to note that it's not ever properly been instituted the way that it needs to, and we're working on that as well. But prior to that, we lost, they were selling in the 1950s, they were selling indigenous children from these religious government-funded schools for $10 in South Dakota. You could get you an Indian kid for $10 for slave labor, in essence. So with that foundation, I want you to understand that what we're talking about today is not just some law that comes and goes. This is the very foundation of what we need to protect our people and our way of life. And I want to start because, Dov, you played such an important part of this brief that you're filing with the Supreme Court. And first of all, let me say, Wopula, for all of your efforts and your energy. And I know you've been having to travel everywhere and do anything and simply standing and fighting for our people on this. But I think it's important that people understand this is not just an attack on children, but this is an attack on our sovereignty as nations as well, as we've already seen that. Can you just talk to our viewers a little bit about what you've done within your brief and why these issues are more than just that are so important in protecting our children, but more than just that?
Yeah, I appreciate the question, Shaun. First I should give credit and recognition to the attorneys that have been teaching me and have been working with. It's not a solo project. Obviously also to Lakota Law for all the work they do for Lakota country and Indian country and for Native people across Turtle Island. It's been a privilege to work for you guys for a few years now. And I've been following your organization for a much longer time. And so I'm just here along the way, basically. But what's going on right now is you're seeing a Supreme Court that seems to care little about history. It's not really limited to tribal sovereignty. It's obviously you're seeing it with voting rights, you're seeing it with reproductive rights, you're seeing it with equality in general. And what's going on now is they're going to hear a case in November. They decided yesterday, November 9th, to hear Brackeen versus Holland. And it's going to decide whether the Indian Child Welfare Act, which has been on the books for, as you've said, Shaun, almost this point, almost 45 years, whether it's still valid and constitutional. And for starters, the law is really important for Native people. It's one of the few laws that tribes across the continent have praised for its significance for safeguarding Native children, for giving their communities deciding power over where their kids go when they're up for adoption. But on the other hand, the law is a foundation. It's a starting point. It's not the be all end all. And so right now the court is going to hear whether this law is valid, whether it's constitutional, and they're going to address one question, which is basically whether it's racist against non-Native people to have a law that basically establishes a preference scheme. So when a Native child is up for adoption, for 100 years, the state would just take the kid and put him in with a white family, cut his hair, tell her to stop speaking her language, and if she didn't, she would be hit, she'd be abused. And the law was there to basically prevent that process from at least happening immediately. It hasn't prevented the process from happening. It's just slowed it and made it harder for white families, or often white Christian saviors, as they call themselves, to redeem Native kids. And so the short end of it is that the law has a provision where if a Native child's up for adoption, if the kid's own parents, can't take care of the child, or the kid's extended family can't take care of the child, the kid's own community will have a say in the child's adoption. And from there, it'll go to any Native person in the U.S. who's a member of a federally recognized tribe, which is itself a controversial conversation. But the short end of it is that you have these very far right wing groups, and I don't mean that with any political valence. It's just how they identify, who see the law as another example of reverse racism. They see the law as something that favors Native people and in the process prevents white families from having the ease of access that they've been so used to for centuries, right? To take Native kids, and not just Native kids. This applies to Black kids. It applies to Latinx kids, Asian kids. One of the Supreme Court justices has a number of adopted Black children, and she's probably one of the biggest threats to the law because she herself believes in the power of redeeming people towards Jesus. I'm not Christian myself, but I believe everyone's entitled to their own faith and religion. But when it becomes something that you push on others, it's a whole different conversation. And so, I mean, there's a million things I could say, but the short end of it is that you have a court right now that seems to have little regard for history, both history of people and societies, but also history of its own law. The court just threw out a precedent, the Roe v. Wade precedent, which people had trusted to be secure for decades. And, a couple weeks ago, they decided that states are allowed to prosecute crimes that happen in Indian country when that for so long that wasn't the case. And the decision that the judges wrote, basically ignored 200 years of not just precedent, but actually what's been going on in Indian country, right? So that's the short end of it, is that what we're faced with right now is two complicated legal questions. On one hand, you could hope the court takes a thorough eye to it and makes a smart and clear and holistic decision. But on the other hand, given the track record we're seeing in the last year since the court took shape the way it is now, there's a good chance they might just disregard history too and pretend like this law has done more damage than good for people. So I could keep talking about it, but I think I'll rest it there.
Yeah, and I appreciate those comments so much. And I also want to say I appreciate all the comments in the chat. We're going to address a lot of these issues. I'm seeing those, and we want to talk about those issues with you because we know that they're real. Dov, I do want to ask you about this, and I can't wait to speak with Decora on this because Decora is doing with a grandmother's group on the Shaun River Reservation, is doing a phenomenal job, a life-changing work that they're attempting to get done there. And I want to talk about that in just a moment, because the truth is ICWA works. The problem is ICWA isn't working because it's the only law that's not properly, it's not audited, it's not overseen, it's just there. And right. So if it's not overturned at LPLP, we're focused on going to each state individually and making sure that this is fixed and this is right, because it does work when it's actually instituted. But I want to ask you this before we move on, because this is the frustrating part for me when it comes to the way this law is being challenged. And for those that aren't familiar, I'll try to give you like the 30 or 45 second, my version of that, I don't know how long that'll be, version of what's going on. There was a Navajo child who had been with a grandparent's son. He was taken from the parents because of substance abuse. And what happened was what's not supposed to happen. He was moved to Texas with a white family, and that white family then tried to when the Navajo Nation found a family member close and had a relationship with the child, they tried to block it from happening. The courts quickly sent it down, and that's when Gibson and Dunn gets involved. And this blows my mind, Dov. Every time I see it, 6 days after it was turned down, Gibson and Dunn, who is known for fighting for the industry, the companies who are responsible for DAPL, they're responsible for Line 3, I believe Chevron, some other those types. They get involved on this issue, and probably just kind of blows my mind even more. Then the Attorney General for the state of Texas gets involved on the family court level, which is very, very unusual. And perhaps even more unusual, 3 other states come along who only represent about 1% of the population of Native people that would ever face this action. And so there seems definitely to be another objective. But here's the frustrating part for me. They are suing on the fact, ICWA's been challenged before, but they're suing on the fact, if my understanding, please correct me if I'm wrong, though, they're suing on the fact that we should be looked at as races, not nation. And by looking at as races, that the white families is getting reverse discrimination because of this. But the United States has already settled this issue, in my opinion. It should have never been to this point, because the reality is this: the United States of America does not make treaties with organizations or companies or nonprofits. They make treaties with nations, and we are tribal sovereign nation. Article 6, Section 2 of the U.S. Constitution, which all of us are very familiar with, all treaties shall be, not it's recommended or could be or might be or ought to be, all treaties shall be the supreme law of the land. Is that something you were able to address, Dov, inside of this? Is that the Constitution already tells us we're nations. We have this right.
No, it's a good question. And the thing is with an amicus brief, which is what the court of law provided to the court, an amicus brief is supposed to be a narrow comment. It's supposed to speak from the perspective of the organization or the person involved or who feels relevant. Amicus means a friend of the court. And so, in the briefs for the tribes and for the law in general, they're addressing this issue, right? The nation-to-nation relationship, that any law like ICWA that they're called special treatment laws or preference laws, where a law is written for a specific group of people. That's being addressed in all these other briefs. We had a specific lens, which is from the perspective of the senator who wrote the law in the 70s, named James Aberesk, and he's from South Dakota. He was a huge advocate for Native people, for oppressed people across the world, a huge opponent of the Vietnam War, of militarism, kind of a rare guy for his times. But yeah, to your point, the law is being challenged because of that. They're saying that Native people are a race group, and that it's any law that exists that privileges Native people is it's racist against other people because it doesn't include those people. Now, as you said, Shaun, it's been settled in law for a long time. And when I talked about the history that the court might want to throw out, the court throughout the 1970s and in the 80s passed a number of very, very clear decisions, even where the decisions were against Native people in the end, but they highlighted what they had said in a case in 1974 called Morton versus Mancari, that tribal nations have what's called a political characteristic, right? They're a classification of politics, not of race. And so a law that is directed towards a tribe or towards Native people largely has nothing to do with race, which is itself a big buzzword invented term used to kind of suppress difference in a way. But those laws are rooted in those people's membership in a nation, a tribal nation, a tribal government. And so, yeah, that's the question here. And anyone who's involved in Indian country knows fully that that's precedent, that is good law. The thing is that we have a court right now that, as I said earlier, doesn't seem to care much for that kind of stuff, and are very quick to jump on to the race baiting bandwagon that we've started to see from the right, especially in the last couple of years. And just to make one point about you mentioned the family themselves in Texas. They're openly, they speak about it. It's not something that has to be dug up. They call themselves white saviors. They believe that is their mission on earth. And the most sickening irony of all this is that they successfully adopted the Navajo child. This law firm, which has enormous backing and support from the fossil fuel lobby, as you mentioned, Shaun, from major the war economy, just major far right, very sketchy interests. They saw a perfect opportunity here because they told this family, well, listen, maybe you've won the adoption or you're about to win the adoption, but the law has made your life hard, right? It's made your life difficult. Now you know what it's like to be the victim of discrimination. And so this family, they ended up wanting to adopt the boy's sister. They said, oh, he'll be better off with his sister and she'll be better off with her brother. But the short end of it is that they won the adoption proceeding and still claim that the law got in the way of their, equality, their equal rights as people. So, again, it's one of those things I could talk on and on and on about, but the background to this was just to finish is that Gibson and Dunn is sponsored by the oil and gas industry, the coal lobby. And what they see here is a perfect opportunity to, with the striking of a law, open up Indian country to erasure and to take over by industry. And the last part too is that if this law falls, it'll set precedent for a lot of other laws, including casinos, which are questionable in their own way, but give Native communities access to revenue that other groups don't have access to, as well as natural resource law and land use decisions. And so basically, if the court strikes this law and says it's a racist law, or it denies equal protection to non-native people, you could see a lot of other things following that will gradually weaken the ability for tribes to, keep around and continue to grow their membership and define their own boundaries. And so it's a bigger issue than it looks. It's like an iceberg, way more below the surface than you can see.
Absolutely. Appreciate so much those comments. And I can't help but think about the fact that, you have this firm known for their, no DAPL, or excuse me, for DAPL, known for Line 3, known for all of these. If they can get the Supreme Court to say that we're a race and not nations, now that opens up a whole can of attacks on our tribal sovereignty. Now you can go get all the resources you want because we're not a nation, we're a people, and that's not our land, that's not our rights. And so it's leading to the attempted erasure. That's why I say I believe this is by far the most important, crucial time since the 1970s. I want to move now to Decora Hawk. Decora has a tremendous background, not only in education in American Indian law, but as an activist and an absolute star for our people, always on the front line fighting. And Decora, when we talk about ICWA, you and I, you've had multiple times, I had an opportunity to go up with you to Cheyenne River, and we sat there and we listened. The first time when I was there, we listened to 9 hours of testimony of people and children that were absolutely abused by the system, even with the protection that ICWA is supposed to give. And if ICWA is upheld, then we've got a plan at Lakota People's Law Project to go forth and really begin to see this instituted, overseen, and people held accountable. But as we were going through that, Decora, I couldn't help but think about the words of Crazy Horse. After they had defeated Custer and being questioned, he said these words. He said that we never wanted to fight. We never wanted to war with the United States, in other words. All we wanted to do was be left alone and live our lives as we had always lived our life. And that's what I believe we have to say to the Supreme Court today. We know best what is best for our children. We know best how to lead our children into who they were created to be. We are best suited to provide, and we are best suited to take care of. And though it may not fit your terms of colonization or your terms of what it's supposed to look like, it works for us. And it works magically. And that's why we've survived years of genocide and all of these things against us. Decora, can you just speak for a moment? I'm sorry, Decora, if we can just hold for a second, if you don't mind. I want to play this video that Madonna Thunderhawk and the Uchi group that you're working with. If we could play that video, and then I want to begin to comment on this because this is a big battle. If ICWA is overturned, we got to fight to get new legislation passed to fight for our tribal sovereignty and our life and our way of life. If not, people like you and this wonderful grandmothers group that are fighting for the right for our children and to hold people accountable for the law. I want to talk about that, but if we could, let's show this video right now about the work that's going on the Cheyenne River Reservation.
I'm part of Wash-Agia-Naji, Standing Strong Grandmothers Group. One of the main reasons we organized was because of the child welfare issues on our reservation. For example, many grandmothers, young grandmothers and older grandmothers, are raising grandchildren. And many of them have been taking care of these grandchildren for whatever reasons since they were born. But all of a sudden, when it comes to court, the grandparent or the family member who's raising them and has been raising them has no standing.
I have grandkids and great-grandkids, but I'm really in for that kids that been sending out to off reservation. Grandkids call crying and they don't want to live there. They want to be with their own grandparents and they don't know how long they're going to wait. Just like me, I don't know how long I'm going to wait.
We're having reservation-wide hearings. We've got the support of the tribal council as well as the tribal chairman. So come September, we'll have our findings documented and we'll be requesting that the tribal government establish a child welfare department. We, because we've talked about it in our group, grandmother's group, we see it as a multi-service department with all the wraparound services for that child, for their life, which means their family is included. Because in our way, you help that person, you help that family for the sake of that child.
We can do something about it if they get a lawyer and a department of our own.
It's community. And when it's community-based, you just stay with it, and work on it, because it's who we are. It's save our children, save our families.
Decora, I'm not a overly emotional person. I feel it, but my emotions don't normally pour outwardly. It's that mechanism of protection so many of us have had to build around our own lives. I've experienced personally. I'm a victim of ICWA not being properly instituted and taken care of, and the struggle that had for me to get back and find my place of who I was, and to connect in a way that I could never repay my nation for helping me to go to. But I want to say this, Decora, if you could you share just, I know there's a little bit in there, as I think about those testimonies we heard and the experiences and the from abuse, neglect, all the things that happened once they were removed from our communities and our people. Can you share just a little bit, first of all, about what you and the grandmother group are doing in Cheyenne River, and some of the obstacles that you see that we have to overcome to help our people really go forward and strive?
Yeah, thank you, Shaun. Hello again, everyone. So most of my organizing work has been happening on Cheyenne River Reservation in conjunction with the grandmothers group. And right now we're trying to encourage the tribe to create and develop their own tribally controlled and operated child welfare department. And this particular issue with ICWA being challenged, it's really important that Indigenous nations take into consideration that they should definitely take control and take power of decision-making on what happens with our Indigenous children. Right now, we are currently collecting testimony. We are setting up in different communities and different districts on the Cheyenne River Reservation. And we are holding these hearings where individuals are able to come to us and tell us their personal experiences that they've had when dealing with the Department of Social Services in regards to their children and their grandchildren. One of the main things that I'm seeing is, there's just a total separation when it comes to state standards and cultural practices, right? And these are putting our children in danger because, our cultural practices and our cultural beliefs are not aligning with how the state of South Dakota, how they want to perceive family dynamics. And so that was like a main thing for us, was coming across this and that cultural separation and misunderstanding, just total dislocation. And, another thing that, we were experiencing were stories of children having that experience as well, being placed with non-Indigenous families off the reservation, off tribal lands. They weren't feeling seen, they weren't feeling heard, they were experiencing different types of abuse. And, there were situations where there were individuals who were crying out to their family because of these situations. And so collecting this information is really important so we can consolidate it and provide something to tribal council to show them just how much this is needed and just how much having our own Department of Child Welfare will benefit our children, because they'll have the necessary resources that they need in order to thrive. They will have parents and grandparents will have the necessary resources, but then also the opportunity to construct our own set of standards, and what will be the best for our people. And I really appreciate, Shaun, that you used a quote from Crazy Horse, because that's exactly what I see, and that's what this group sees as the future, is being able to have that self-determination and make those decisions and know what's best for our people and for our children. Hechekla.
Absolutely. And we sat through these stories after story, and I want to acknowledge one of the people that posted. I'm going to absolutely butcher that name, because I am terrible at pronouncing names. The last name I believe is Canby, but she is a tribal child welfare social worker, and she says, I can attest if they work, keep the kids with family. And I just can't say this enough. This is one of those things that you have to be in the community. You have to be in the culture to understand what we're talking about. A lot of people, we're in the United States now, it's called, and we're considered in this United States to be a melting pot. And it's a mixture. And because of that mixture, a lot of people don't have that real true connection to their heritage. And I understand that. And that's difficult. But I think it's also important to note that we're more than history. We are a culture and a community that is here every single day, living our lives and trying to live in our lives in a way that honors our ancestors, that not only honors our ancestors, but provides for the 7 generations that are coming after us, that our relationships with Unchimaka, that our relationships with one another, how we parent, and all of these things were affected by colonization. I mean, let's just be real. I'm not here saying that every child that is taken out of a native home didn't need to be removed from that home. We have problems, our own problems within our own communities. What we're saying is that being separated from your mother or your father is difficult enough. Separating them from the way of life and our culture and our community, that doesn't just a t-shirt for us. It is who we are as a people. It is what completes us as a people, is what fulfills us as a people. And as Crazy Horse said, we are best when we're allowed to be who we are. Do you think that is one of the major issues? It's not just be taken away from families. That's tough enough. But to be removed from our culture, our community, and our way of life is so crucial to be able to avoid and to stop that we are allowed to be who we are as a people.
Yeah, you're right. You're absolutely right. Being taken, away from your family unit is hard enough. But imagine being taken from your relatives and your extended relatives, and even, individuals who are within the same tribal boundaries, that, understand your way of life and how things are as an Indigenous person of that, that tribe. And whenever you take children and you place them with non-Indigenous families off reservation boundaries, or in border towns, and that is totally, it's severed, right? And we need to keep our children with our people, to cultivate and keep our identity and our traditions and our teachings strong. There's for example, Pine Ridge Reservation. So one of the things that I noticed is that there's so much connectedness, right? There's so many teachings that you get from not just your close family, but extended. And, we have this really tight knit community. And it's really important to keep the children where they belong with their people.
If I could
Absolutely.
chime in, Shaun,
Yeah, please.
one thing that the brief that the Dakota law sent to the Supreme Court, one thing that it highlights is that what is really special about the Lakota country is that, well, it's born of a bad history, which is that the Lakota people were far more unified before the allotment era, and when reservations, also known as prisoner of war camps, even though that's not how they're taught in schools, when they were divided and established, it also divided Lakota people from each other. And, for example, like one of my closest friends is Oglala, but she grew up with her family at Rosebud. But those are two separate tribal nations in the eyes of the U.S. government. And so, for better or for worse, but for the sake of the law, if this law is struck, if her nephew, right, were up for adoption, it wouldn't matter that he had family over in Rosebud, because now it would be racist to have him be raised by his auntie or something over there, right? Even though it's just 10 miles down the road. So one thing that our brief stresses is that Indian country is united by these family linkages, and how white or settler society doesn't have the same relationship with family. It's more nuclear. If there's no mom, dad, well, the kid must be neglected. That's not the case in Indian country. That's not the case in a lot of other cultures. And I know, Shaun, you mentioned this, and Decora, you touched on it, but it's a different culture. And when you are removed from your culture, it's easy to lay down a very simple, rigid, if there's no mother and there's no father, well, the kid, has nothing. And well, that's not true. And often it's the aunties, or the grandmas, or the grandpas that do a lot of the raising, not just because maybe the mom or dad is too busy working, but sometimes because you need an older figure around to run the show. So that's one thing that our brief talks about. Another thing it talks about, which is what all you guys have been talking about too, it relates to, is that South Dakota is an exceptionally bad place for Native people, especially when it comes to Indian Child Welfare Act. And when the law was passed in 1978, it took years of hearings and testimony and evidence from all different sources, from Native people themselves, from kids who had been caught up in the welfare systems. And at the time, Native kids in South Dakota are 22 times more likely than any other person, namely white people, to end up in foster care. That was the highest rate of the country, period. North Dakota was a close second. And then, that report that Lakota Law was involved with back in the early, around 2012 or so, found that 90% of Native kids who were removed from their homes in South Dakota up until that time, these are all state records, 90% of the Native kids who've been removed from their homes all ended up in white homes. 90%, which is a clear indication that the state wasn't trying at all to follow the law. And there's clear evidence that they never cared to. And, we can get it. That's a separate conversation. But yeah, that's one thing that, the court doesn't have much respect for, but we need to double down on, is that Native people are not white people. They're not settlers. They have a completely different culture. And I know doesn't mean it's one culture, but there's certainly more, you can't paint all people with one brush, but there's certainly more relations and closeness between Native people than there is, from Native people to non-Native people. And that's what the law, as much as it is a starting point, not a final, great solution to everything. The law at least acknowledges is that a Native kid in one home would be better off in a home across the country, but with another Native family, than he or she would be with a white family, even 30 minutes away, because you never know what that family's intentions is going to be. So.
Absolutely. And thank you for that. I mean, that's very, very important and very crucial. I want to address just real quickly a couple. I know I'm going to miss a lot, so please keep them coming. I'll try to see as many of the messages are. Two in particular I want to respond to real quickly if we could. Kimberly asked, how can we get Native American attorney to fight with us in court to try get our son back with ICWA? Kimberly, it's first of all, let me say, I've been the child in this situation. I know I can't imagine going through it as a parent and what you're going through right now. And I just want you to know that you have, first of all, my prayers that this works out. But Kimberly, if you could, if you'll email me at Shaun, SHAUN @lakotalaw.org. I'll send you some resources, some things that we have available that are out there, some things that we've collected over time to try to help in these things. And hopefully some of that will be valuable, because you're fighting the most difficult war that could ever be fought against a system that wasn't built for you. And so I want you to know that we will do, I'll get those resources to you, and anything I can share or people I can share with, I'll do that as well and get a little bit more information. I also want to address Michelle. talked about a few different posts, talked about this system that's not built for us. And I think that's important to acknowledge. This system was meant to eradicate us, not to promote us or make us better. And so I think it's important, but this is why this fight is so important. Because to me, the most important issue we have as indigenous people of this land and tribal nations is sovereignty. Because all of these issues fall under the umbrella of sovereignty. If we have true sovereignty, if we truly fight and get the sovereignty that our treaties and the U.S. Constitution guarantees to us, then we don't have a problem protecting our children. If we get sovereignty the way we're supposed to, and we fight and get that sovereignty, we don't have problems protecting our missing and murdered indigenous women and Two-Spirit, because we have the ability as a sovereign nation to do whatever is necessary to protect our parties and our people. And again, we have always flourished when we're left alone. So what does the U.S. government do? They always try to overrate us. They always try to find ways to bring us to that level. So I acknowledge that what you're saying is absolutely correct. But this is why ICWA is so important, this fight right now, because it is an attack on our children and it is an attack on our sovereignty. And we must fight within everything within us to make sure that if it's struck down, we've got to instantly get legislation passed and new things passed. We have to, as a people and 570 plus nations, come together and say enough is enough. We've got to come together and say, one of my favorite quotes, if you've heard me speak much, you've heard this quote probably, but I actually heard it in a video by his son, but it's a little clip that gets lost on YouTube a lot. But Russell Means was talking about being called radical. And he said, maybe it's true I am radical. He said, but the only thing that I've ever fought for, the only thing that I've ever been shot for, the only thing that I've ever been stabbed for, the only thing that I've ever been arrested and thrown in jail for is to ask and demand that the United States of America live up to their own laws. And we are to that point again, that we have to come together as people and nations, and we got to stand in the face of the United States of America, whether it be the Supreme Court, whether it be legislators, Congress, president, whatever it is. And we've got to ask, but we have to demand that the United States of America start living up to their own laws. If they do that, I promise you, as indigenous nations, we will flourish. No, we're not perfect. Yes, we have to overcome the damage of colonization and how it changed our landscape as a people. But we can only do that if we come together and start demanding that the United States of America lives up to their own laws. Decora, we know that ICWA maybe has not been as effectively implemented. And we know that and thank you, Dov, for saying that, the South Dakota, where we live in the Glala Lakota Nation, which was within the state boundaries of South Dakota. We don't live in South Dakota. We live in our own nation. I think that's important to acknowledge. But we see within our nation and what the state of South Dakota is doing to our children. And we heard a lot about people not having true representation and help when their children were taken, many times without calls. And I know I can't get into specifics because those testimonies were done in a certain way. And so I will not violate their privacy or the rights, but it was heartbreaking to hear these stories. And so it matters that we make sure that this is implemented, because the reality of it is, as we go forward, our people need representation against when these issues come up. Now that we're not perfect and we don't have issues, we heard people talk about not being able to adopt their own family members or to foster their own family members. We talked about people not having proper legal help, that they would rather pay white families outside of the Glala Lakota Nation and the Cheyenne River Nation. They'd rather pay those people to take care of our children than to help us get the help that we need in our own nation. That, quite honestly, they're the cause. So did you find that need for representation being the thing that you're hearing over and over again, that our people are being tried and kids stolen without true representation that they deserve?
Yes, the number of times that I've heard that during this process is outstanding. Um, the need for representation is huge, and there was a lot of individuals that didn't know how to navigate the process, and I feel like they, because of that, they had been taken advantage of. They had a disadvantage because they just didn't know how the system worked, and nobody was there to tell them. And it's really important because the Indian Child Welfare Act, it has provisions to help protect children, and it's really important that we protect ICWA, because all of these individuals, if ICWA is struck down, they won't have a chance. They won't have a chance. And so that really goes hand in hand with what we need. And we need to protect ICWA so that we can help our people through this process and through this, extended family members who want to step up. So thank you.
And again, I know we're near the end. I just got a couple more things. Dov, one of the questions that we got, one of the comments is, how do you feel about calling us nations instead of Native people, specifically Lakota, Sioux, MHS, Ojibwa? Much of the legal hurdles seem to stem from labeling ourselves as a race. And I know that, depending where, both of those are kind of interchangeable, right? Sometimes we say Native, sometimes we say our particular nations when we're dealing with multiple. Is that kind of the foundation of what you're seeing, is the attack because they're not recognizing our sovereignty as nations and just trying to classify us as a race?
Yeah, it's a good question, and that is what's happening. I mean, we'll see what the court decides, but that is sort of how that's the risk that we're facing, is that the court will reinterpret its long understanding of Native people as members of tribal nations, which, by the Constitution's words, are on equal footing with the foreign nations and the domestic states, so the states of the United States and foreign nations like France or, Chile or whatever, Chile. So that's the risk. And what comes with it is a total revision of what the U.S. has, even when it was, fighting against Native people, like it always has been, but when the laws were not supposed to help Native people, but explicitly to hurt them, it was still on the basis of their membership in these nations, right? You're at war with them, that you can't trust a nation you're at war with, etc. There's almost some respect you have to give to that, where, yeah, the policies were genocidal, but at least they were acknowledging the nation to nation relationship. Now it's just, it's a war on people as individuals, and it's when you racialize people. I mean, someone mentioned this in the chat, but it's dividing and conquering. It's you water that person down to their individualness. Oh, you're this race, you're that race. It's no longer about your connection to culture or to community or to to sovereignty. But when we wrote this brief, we had to be careful with our words too, because when you use the word tribal nation in a court, it also has the ring of how do I say? It can be viewed as too headstrong, and you have to use a technical words, which is not tribal nation, but tribe or Indian tribe. You can't use indigenous people in the court. You have to use Indians, and that comes with its own set of loadedness. And yeah, there's a comment here in the chat that this government will never want to work with indigenous people, and I think there's a lot of truth to that. But while we're at it, we have to take or make the most of the positive things, which is, even if we could see them as figureheads with minimal power, the head of the interior, the first person to oversee the Bureau of Indian Affairs, who's a Native person, is in power right now, right? Deb Haaland, she's not perfect. She has to report to the big man, but she also is, a sign that things are changing. The head of the National Park Service is a Native man. Many of the interior people are Native people. And so, it's a weird time. There's a lot of, tokenization. But on the other hand, there's possibly a window towards somewhat of a better future. And just to stress with ICWA, it's not a perfect solution, but on the other hand, it's without it, there's nothing. So if we can find a way for it to be strengthened, if it's not struck down, if for it to be strengthened, we can, that's a possibility. But if the law is struck down, well, it's going to be really, really hard to find a legislative solution to that, because the court has already said, well, it's unconstitutional. And it will matter. This is more of a technical discussion for another time, but it will matter if the court strikes the law on what basis it does so. Because there's two questions. One is whether it's racist, basically, and the other is whether it improperly forces states to enact a law that the federal government can't force a state to enact. Like in this case, it's a family law issue, and states are usually the only ones in charge of family law issues. So can the feds force the states to follow a family law, to enforce a family law matter that the feds are requiring? That's a separate question. So if the court says, well, it's not racist, but it violates states' rights, well, then states like New Mexico already states will be in a position to write their own versions of ICWA, which might be a better way forward. So on the other hand, we need to acknowledge that, this is all happening on all stolen land. It's happening in courts that maybe power views as legitimate. But if you are in my shoes, or if you're, believe in sovereignty and indigenous struggle, these courts are illegitimate. But that doesn't mean we can't and shouldn't be working through them, partially because they do have enormous power at the end of the day, and we can't ignore that either.
Absolutely. Decora, I want to thank y'all so much for joining us. The insight, the education, the inspiration that you brought to this conversation. We do have a very, very special guest, the man, the myth, the legend, Chase Iron Eyes. Chase, then we're going to move over to Chase. I want to say, Chase, we're so thankful you're able to join us. Chase has one of the most unique perspectives that you can possibly have on these conversations. And it's always a joy to hear him, because not only is he indigenous, not only is he a lawyer, but he is a person that has lived it every single day, has fought these faults for many years for us. So I'm going to turn it over. I'm going to yield my time now to the great Chase Iron Eyes. Thank you for joining us, Chase.
Thank you very much, brother. And I apologize for this ain't even late. This is straight up absent. I came very, very late, but I thought this thing started at 6 o'clock Mountain, but that's all right. That's my fault. I'm sure you guys handled it as it needed to be handled. And I apologize for missing a lot of the discussion, but I will just, from my perspective, this is a very, very dangerous attack that tribal nations, indigenous peoples, indigenous nations, I heard Dov talking about some of the semantics, very meaningful semantics. And I didn't know that these terms were not allowed in court, but maybe that's a determination among the attorneys that are involved. But we're kind of in this situation where we're like an abused partner, right? There's being born Indian, being born indigenous means that you're born into a war, that you're born into a conflict, a juridical, legal, political, put legal in quotation marks, political and economic attack on our livelihoods, on our well-beings, on our right to govern ourselves, to live by our own accord, by our own natural laws, our own God-given laws, and to seek our own destiny. To be born Indian means that we're born in conflict with a colonial violence. What the court is doing here is a form of violence. The Indian wars have never ended. And not only is this court willing to put Brackeen on the docket to consider whether or not the Indian Child Welfare Act is unconstitutional, to consider whether it discriminates against non-Indians or favors Indians based on race, which is a very tricky distinction that not a lot of people think to make. Because when you think about indigenous people, you think about Indian people, you think about racial justice, you think about liberating from oppression, and you think about civil rights sometimes. And all of those, racial justice and civil rights are noble causes. They're things that people have lost their lives over, They're things that we've sacrificed our blood, sweat, and tears over. We've been targeted. We've been profiled. We've been oppressed. We've been the subject of the security state in this country. It's the reason why Leonard Peltier is still in prison, for instance. But civil rights and racial rights are the apex. They are the epitome of the rights of subjects, the rights of citizen subjects of a colonial empire invented by old Europeans some 240 years ago. If Indians, federal Indians, indigenous people, indigenous nations, if we set our ceiling at civil rights, then we are already dead. We've given our all to defend indigenous sovereignty, tribal sovereignty, and what the Supreme Court calls in Morton versus Moncari, distinct political entities. This means that we are not races. We are not classes within the framework of United States jurisprudence for which the apex of protection is civil rights. No, we are not that. We are the indigenous civilizations in this hemisphere, and we entered into treaties with the United States. So not only are we our own indigenous nations or tribal nations or tribes of Indians, as sometimes we have to call ourselves, but we are protectable, distinct political entities. We are not races. So we have a different framework of rights. So it's very, very dangerous what the Supreme Court is attempting to do right now. But indigenous sovereignty, the contours of indigenous sovereignty are not going to be determined in some courtroom. They're not going to be determined in the halls of Congress. They're going to be determined by those of us who are willing to defend those rights. So sometimes when the state, when the federal government or any state of the union comes to take an Indian kid in violation of its own laws, then sometimes we're going to have to fight back. And the fight that happens on the ground here in our actual lives as Native people will impact and color and inform the jurisprudence that's being developed in those ivory towers in Washington, D.C. So this court was willing to overturn Roe versus Wade. This court was willing to gut the EPA. This court is a bastion, is an expression of the last gasp of dying white supremacy. And we're able to see that more clearly, but we have to be able and willing to step in and defend these rights. Otherwise, they will take them. They are indicating that this is their line in the sand. They're willing to declare war right now. These Supreme Court justices are willing to declare war and cause this conflict inside of our country. And I just want to say about that much. I want to apologize for being late. This is amazing times that we're able to witness, that we're able to partake in, and that we're able to impact. And I want to thank everybody for tuning in, everybody for sharing this stream, everybody for doing what you do in whatever way you do that. Thank you very much.
Absolutely. And Chase, I'm going to go get my tent, some supplies. I'm going to meet you down at Wounded Knee. We're going to go round two if we have to, but I do, man. I appreciate the passion. What you're saying is so true. It's so important. And we appreciate everybody that has tuned in during this. Hopefully that will see this after this as well. I want to note one more time that you can go to our website. The link should be there in the chat. I see it. And we really need your support behind this. We need you to fill out. It'll take you 30 seconds, whether regardless of your race, your location, no matter what it is, we need you to fill this out and support it, because we are at the biggest crossroads since the 70s, as tribal nations and as indigenous people. And as Chase said, our time is now, because here's the thing about us, and Chase knows far better than I, but this is the thing about us. Yeah, we're at a really, really bad spot right now, and things could go really bad. really quickly. But we're at our very best when you push our backs against the wall, and we're not going to stop fighting at LPLP. We're not going to stop fighting as tribal nations, and we're not going to stop fighting with our allies, our non-native allies that are fighting with us. So thank you so much for joining. You've been in Critical Times, a native perspective, the Indian Child Welfare Act, the Supreme Court. Thank you again. This is just a first part of some things that we're going to do going forth. But thank you, Chase. Thank you, Dov, for joining us. Decora, thank you for joining us as well. And thank you for joining us in this fight.